If that had ever arisen, would you have allowed a family member to make money off the notoriety of a case?
I would have recused myself from the case.
To the tune, actually, of $93 million raised for her Democrat clients that include a member of this committee, Representative Goldman, I should point out and put on the record. But also authentic campaigns, of which Lauren Mershon, the daughter of the judge, she runs this firm, Authentic Campaigns, and was paid nearly $12 million for her work this cycle for her Democrat clients, and including $9.7 million by the Biden-Harris campaign.
That was Matt Gaetz and Kat Cammack of Florida questioning John Wilson, a former New York judge. The topic they're discussing is the daughter of Judge Merchan in the New York case against Donald Trump, also known as the political prosecution of Donald Trump. The daughter is the president of Authentic Campaigns, which is a digital marketing agency for nonprofits and political campaigns, which of course only include leftist causes and Democrat politicians. We're not talking about small money either. I've seen reports that are anywhere from 70 million to closer to 100 million. Of course, it's possible that the judge would not be influenced, but that's not the way the system is supposed to work. The equivalent of this would be if you had a lawsuit against a pharmaceutical company and the daughter of the judge was the head of marketing for the pharmaceutical company you're suing.
Judge Wilson, I just want to ask you a precise question. Was there ever a case that you were presiding over where you had a family member economically benefit from the notoriety of the case?
No, never.
You sure you don't want to take some more time on that? Think about it?
I don't need more time. I know that for a fact.
Well, I mean, if that had ever arisen, would you have allowed a family member to make money off the notoriety of a case?
I would have recused myself from the case.
Well, it's just interesting because we had Attorney General Garland who was, spent a good amount of time on the bench, and I asked him the same question, and, he said that he wouldn't answer it because it was obviously a reference to what had gone on in New York. I mean, I thought he might could have answered it, but I mean, when you look at what happened in New York, does it concern you that the judge in that case seemed to have a family member who was economically leveraging the notoriety of the case?
It greatly concerned me, but not so much from the perspective of the ethical violation that would be apparent, because that judge did get an ethical opinion from the Judicial Ethics Committee in New York that exonerated him from any wrongdoing in listening to the case when his daughter was benefiting. What I was concerned about was the appearance of impropriety. When I sat on the bench, sometimes I would get a report from probation or some other organization, and they would hand it to me in an envelope. And I made certain to open up that envelope and show everybody that it was a report that I was looking at, because I didn't want there to be the appearance of impropriety that I'm receiving an envelope from someone in the courtroom. The concept is the same here. You're presiding over a case where your daughter is benefiting and where you've made political contributions in small amounts, but it's irrelevant, the amount. But you've made contributions to the political opponent of the defendant before you. These are the very essence of the appearance of impropriety, and I feel strongly that Judge Merchan should have recused himself on that basis.
Just simple as can be, Mr. Chairman. Straightforward answer to a straightforward question. I wish we could have gotten that from the Attorney General. I yield back.
Thank you, Mr. Chairman. I actually want to follow up on my colleague from Florida and his line of questioning. As Representative Gaetz pointed out, the judge's daughter significantly profited from this case.
To the tune, actually, of $93 million raised for her Democrat clients that include a member of this committee, Representative Goldman, I should point out and put on the record. But also Authentic Campaigns, of which Lauren Mershon, the daughter of the judge, she runs this firm, Authentic Campaigns, and was paid nearly $12 million for her work this cycle for her Democrat clients, and including $9.7 million by the Biden-Harris campaign. Now, I know that there's been a tremendous amount of discussion today about the severe irregularities of the case, some of the things surrounding jury instructions, but I want to talk about the financial motivations for the DA and the judge. So Judge Wilson, you just said that he got a waiver from Judicial Ethics Committee, and you were pointing out how just the appearance of any impropriety, it's to be taken very seriously. Can you talk about the Judicial Ethics Committee, who makes up that committee, and what are some of the processes that they would use? Would they consider the $93 million or her clients or a direct immediate relative that is benefiting financially from this case?
If you're asking me who makes up the committee, it's a combination of lawyers and judges who are selected by the Appellate Division of New York to hear issues that judges bring to them, asking whether or not they can act ethically in particular circumstances. I myself availed myself of that committee on several instances. When it comes to whether or not they should consider the amount of the contributions, I actually think the amount of the contributions are irrelevant because, as you recall, I said Judge Merchan shouldn't have made any contribution in any small amount to political campaigns. That's based upon a prohibition of judges being involved in political activities, except if they're in a window period during their own campaign. At that time, then, a judge's campaign may make a contribution to another campaign or to another political organization. But that's a strict requirement that it only be during an election when such a campaign is made. No, it doesn't matter so much what the amount of the money that was being made. It matters that this is someone of first degree of relationship to the judge who is profiting from activities that oppose the defendant before that judge. And even if he had an ethics opinion exonerating him, saying, it's okay, your daughter's not a witness, and none of her interests are being tried here, so the Ethics Committee thought it was just fine, there's still an appearance of impropriety that's of great concern to the public in general, and that's what a judge wants to avoid when you're hearing a case. You don't want people to feel that your integrity and that your impartiality is being impacted.
Is compromised, right? Which,
and that's what happened here.
And the judge himself had given contributions, and I think you pointed out very appropriately that it doesn't matter if it was a large or small contribution, but the judge in this case, Judge Merchan, he contributed to a political action committee called Stop Republicans. That is inappropriate, correct?
He
I mean, especially overseeing the case of the Republican nominee on the ticket, correct?
He should have known better to make those contributions while a sitting judge.
Right, and I mean, and I see our Democrat witness, Mr. Wu, you're shaking your head. I'm glad that you agree with us that this is a tremendous question mark on the integrity of this trial. But, you know, I also want to talk a little bit about DA Bragg. Now, I pointed out in our previous hearing that DA Bragg raised $850,000 in campaign contributions immediately upon the announcement of the 34 counts. Mr. Fahey, have you seen any other prosecutors run this similar arc of campaigning on getting a particular person and then using it subsequently to raise campaign cash?
Not that I can think of. There might be somebody that's done it before. I think the DA or state's attorney in Atlanta, I think, is doing something similar with that case, using that as a campaign case, her case against Trump. But other than those, I don't know of any. It's certainly possible, but you know, $800,000 for a DA's race is enormous. I know in your circles it's not, but those type of races are usually very low dollar amounts.
So it's safe to say that there's financial motivation in the campaigns by multiple different DAs and politicians to quote unquote get Trump, correct?
At least a political financial motivation, not necessarily personal.
Correct.
Would you also agree that campaign finance law is a complex area and one where a lot of Americans who may have to sit on a jury would benefit from expert witness testimony to understand the alleged crimes that they are being asked to decide?
Extremely so. At one point, Justice Scalia, when he was serving on the Supreme Court, actually said during the middle of oral argument, he says, "This law is so complex, I can't figure it out."
So, Professor Smith, to the best of your knowledge, is Michael Cohen a campaign finance law expert?
Not to my knowledge, and not what I've seen.
Well, yet Judge Merchan allowed him to testify as such during the course of the Trump trial, didn't he?
Yes, in theory for other purposes, but nonetheless, you had him repeatedly saying, "This violated the law," that violated.
So Judge Merchan commented when ruling to limit the scope of any testimony that you would provide that, quote, "There is no question that this would result in a battle of the experts, which will only serve to confuse and not assist the jury," end quote. From the standpoint of someone who practiced as a trial attorney for 34 years, I find that to be an extremely bizarre statement, because that, in fact, is the situation anytime you have a case where expert testimony is needed. In fact, I worked on a case called Nebraska versus Wyoming at one point, and Wyoming had over 25 expert witnesses in everything from hydrology to ag engineering to economics to fluvial geomorphology to all of these things, and Nebraska had something similar. Yet the judge, including the United States Supreme Court, was not excluding expert witnesses simply because there was going to be a battle of the experts. Is that your experience as well?
That is, and I would point out one thing I mentioned earlier, that there are a number of things I would have testified to that would not have gone to legal conclusions, but rather testifying about customs practices, about simply reporting dates under the law, and it appeared from the judge's rulings that even that kind of testimony would not have been allowed.
He wasn't going to allow you to testify to those things, but he allowed Mr. Cohen to sit up there and say President Trump violated federal election laws, didn't he?
Yes.
Professor Smith, going on, do you believe that the court committed reversible error by allowing Mr. Cohen to testify about alleged campaign or election violations?
I think it was erroneous, and I'm not even sure what the standard, not being a criminal law guy, what the standard of review is for that kind of error. And sometimes if it's abuse of discretion, courts give trial judges a lot of leeway, but it doesn't mean the decision wasn't right, wasn't wrong.
Judge Wilson, do you believe that Judge Merchan committed reversible error in excluding Mr. Smith but allowing Mr. Cohen to testify on these issues?
In and of itself, that may not be enough to secure a reversal of the conviction, but there is a concept in appellate law, a cumulative error. And what I believe we've seen in the Trump trial is a series of errors, one piled upon the other, cumulative errors that when you put them all together show that Donald Trump did not have a fair trial and that his conviction should be reversed.